Research has shown that the best dispute boards are multi-professional because of the various aspects that arise out of the disputes.
Yeah. When we're talking about design, disputes, and decisions, we're also looking at those tiny decisions. We call them tiny, but they can actually arise into huge disputes if they're not fully responded to along the life cycle of any construction project.
So we exist basically for that reason. So we are the first professional organization that brings together professionals and experts in the built environment to sit on a round table to come up with solutions to the challenges that we are facing.
You know, before you even get into budget, you want to first understand what the client is looking for.
The risk always goes with the reward. So the higher the risk, the higher the reward.
Definitely. There is an element that I find many of our Ugandan people, professionals included, have a weakness in, and that is the element of communication and keeping records. What do you have to say about that situation?
We need to change the 3 R's to the 3 GR's, and these are good records, good records, and good records.
Welcome to Design, Disputes, and
Decisions,
a podcast by the Uganda Society of Architects and the Contractual Law Institute. We are your hosts. My name is Namayanja Jacqueline, the president of the Uganda Society of Architects, and with me is
David Kagwa. I am the executive director of the Contractual Law Institute and the chairman of the Chartered Institute of Arbitrators Uganda chapter.
Thank you for being with me, David.
Yes.
This partnership of the Uganda Society of Architects and the CLI is a very strong and strategic partnership. But before we get into the business, tell me something. If you were a song, what song would you be?
If I were a song, I would be a song by Bob Marley. I'm not so sure of its name, but I can try and sing it.
Please.
Sing it, don't worry about the thing, 'cause every little thing is gonna be all right. That is the song.
That's where it ends?
Yes.
Okay,
Yes.
Thank you very much.
You're welcome.
Why do you like that song?
Well, the world is full of so many ups and downs, and as leaders or practitioners, we are faced with challenges along the way, along our journey.
Yeah.
So in order to stay fast in that journey, you just don't need to worry. Because when you don't worry, then you are always thinking about solutions.
Something.
Yes.
Is it bad to always think about solutions?
It's always good to be thinking about solutions, because when you're a leader, the people that you lead expect you to pilot the institution properly. They do not expect you to be telling them about challenges. So as and when you have an issue to deal with, play Bob Marley, don't worry, you'll get a solution. And once you have solutions, this organization moves on.
So do you also like that song of Don't Worry, Be Happy? Very similar to what you're talking about.
That is your song. I think it's a good one. We need to have both of them. We need to have both of them. Yes.
Okay, so the Uganda Society of Architects is a professional body that was started in the 1966. What we are about is lobbying, advocacy, and looking for opportunities and securing opportunities for the architectural professionals. We unite architects, practice, the architectural practice, education, and research. Because we're a body that unites architects and other architectural professionals, we know that the practice of architecture really has a lot of legal. It's a regulated professional practice, and therefore we encounter a lot of legal instances. And I'll let David to talk about the CLI just briefly.
Well, CLI was founded based on a pain point that projects were always delayed. Yeah. So we set out to do research to find out why projects are delayed. And one of the critical causes why projects are delayed, especially construction projects, is lack of coordination amongst the various players in the construction industry.
Yeah.
So we set up to create Contractual Law Institute to unite professionals and experts to come up with best practices that are good for the built environment. And we do this through training, advocacy, and research. So we exist basically for that reason. So we are the first professional organization that brings together the professionals and experts in the built environment to sit on a round table to come up with solutions to the challenges that we are facing.
Sure.
So it's from that background that we can only validly exist through collaboration. And I'm happy to report that our first collaboration was with the Uganda Society of Architects.
We are happy to collaborate.
Yes.
And that also rhymes with our vision, which is to champion excellent solutions for a sustainable built environment.
Yes.
And our mission, which basically is to be a voice that unites, adds value, fosters growth, and secures the architecture profession in serving the community.
All right.
And so whatever we're doing here and all our strategic partnerships are about serving the community.
Yes.
And championing those solutions. So, as you mentioned, that the first partnership is with the Uganda Society of Architects. The Uganda Society of Architects has an MOU with the CLI. Going forward, I'll use the USA and CLI.
Yes.
We can't go in the full descriptions. And we came together really when we discovered that architects are not in the space they need to be. And because we're constantly growing and understanding, even as we are professionals, but we're constantly growing and understanding the field in which we're in, the trends that are changing, the market needs. We realized that our regular experience of managing a contract and a building project and a construction project entails us to understand how we can actually intentionally avoid disputes and be able to bring solutions to whatever disputes arise right from the beginning. And so we identify the CLI as a very good partner because like you have explained, your vision and your mission, you would be the best people to get us there where we need to get. And therefore, this podcast is actually founded on that MOU.
Yes.
So why are we what's the purpose of this podcast?
Well, the main purpose of this podcast is basically to disseminate information to professionals and the general public about the role of both institutions in ensuring delivery of projects within time,
right,
within the cost that has been estimated by both parties, and with the best quality. And the best way we can do it, amongst others, is first of all to make sure that the right professionals are appointed to their various roles. That is, the architects are playing their roles, the quantity surveyors are playing their roles, the valuers are playing their roles, the construction lawyers are playing their roles. So the name of the podcast, Design, Decisions, Disputes, also portrays the various roles that these professionals play.
Yeah.
And why we need to synergize and work together.
True.
You, the architects, do the design, you do the concepts of these projects. It is you that gives birth to this project.
Right.
So when you do the concepts and the design, those designs need to be put into effect by a builder who must build according to your design and specifications. Now, once the project has started, there is the aspect of decisions. Now, you, the designer, most likely you are appointed as the project manager. So there are decisions that you play right from responding to requests for information, way up to making certification decisions that lead to payment. Many a time when there's been a delay in payment or a dispute regarding whether or not certain work was properly measured or certified, then we go to the aspect of disputes.
Yes.
Now, those disputes, there's a different layer of people who make that decision. The architects can still play that role, but not the project manager at this time to avoid conflict of interest. But now there's a new concept of dispute avoidance and adjudication boards, which are set up by professionals from various areas in the construction industry. Research has shown that the best dispute boards are multi-professional because of the various aspects that arise out of the disputes. So a perfect dispute board would have an architect as a member, it would have an engineer or a quantity surveyor as a member, and without a doubt, it should have a construction lawyer, because one of the main causes of disputes is failure to interpret contracts properly. So that's how the 3Ds come together to enable us to have this discussion.
Design, disputes, and decisions.
Yes.
Thank you very much for that breakdown. And I just want to add on the fact that this being a collaboration or marriage between the architects and the legal side, which is the CLI. Design, we're talking decisions that run through the entire process of a project, right from initiation to handover. In this case, we're going to focus on the construction project. Yeah. And the architect starts the entire process. Once the client calls up an architect and says, David, in this case, you're going to be the architect. I would like a house.
Yes.
I'd like a house. And what would you tell me?
Well, I'll ask so many. The first question would be, what is your budget?
Mm-hmm. Is that the first question?
I would think so, because I don't want to give you a 10-storied house. So I think, well, I'm not an architect. I don't know. Maybe you'll have a better answer. But I would imagine the first question would be, what's your budget? So, Jackie, what will be your answer?
Well, what usually happens is the client will call you up and tell you, I want to build my house. And you meet up, you have this discussion about what exactly he wants.
Yes.
Before you even get into budget, you want to first understand what the client is looking for.
Okay.
And so the project initiation has a lot of discussions, which get into feasibility as well, feasibility discussions. And then you get to understand what's the next step after that. What's the budget? What's the timeline you're looking at? What's the focus? And this entire time you've gone to look at the site, you've gone to look at, we have these other things that happen as architects, which I don't want to get deeper into. Perhaps we can do that along the way in the rest of the episodes. So when we're talking about design, disputes, and decisions, we're also looking at those tiny, tiny decisions. We call them tiny, but they can actually arise into huge disputes if they're not fully responded to along the life cycle of any construction project.
Yes.
Now, you earlier mentioned certification. You talked about measuring works. But I want to say that throughout the entire design decision, the entire design process or stage, there are decisions being made, an interaction and interface between the architect and the client, the architect and the engineer, the other consultants that are on the project. But the architect provides that canvas. And of course, I think we are going to get into the fact that before even you start working, once the client says, yes, you're the person to do the job, then you get into the contract. Yes. Would you want to add on something to that?
Well, you've said it all, and I like the way you have systematically stated it. But now when you reach the level of the contract, it's now critical to ask yourself what the extent of risk that either party is willing to take. The risk always goes with the reward. Mm-hmm. So the higher the risk, the higher the reward.
Definitely.
And to put it in context, if you expect a contractor to take up the risk of design, and you're giving a design build contract, then expect that the total value of the contract amount is going to be relatively higher than if the employer was to do the design themselves. So at that level of choosing the best contract, you need to have the discussion of what kind of risk are the parties willing to take. So if I'm an employer and I find that I'm setting up a project which is complex or it has a lot of equipment. I'll give an example of a factory. A factory, other than the building itself, it needs the equipment, it needs air conditioning, it needs specialized mechanical works. So you can make a choice that I'm going to go out to tender for a design build contract.
Yeah.
So I'll pass on the entire design risk to the contractor. So it means you should pay a premium for that kind of contract. So at that level, that's what you're going to ask for. If you're not willing to pay that premium, then you say, okay, I'll do the design myself. So you go to Jacqueline and say, Jacqueline, please do for me the design that the contractor is going to tender for. And that way, you will retain the risk of changes in quantities due to design issues. And the contractor will only have the risk of ensuring that they build according to the drawings.
Yeah.
Yes.
I want to go back to the issue of design because, it's the first D of our three. That means that it's going to take up a bit of our unpacking.
Yes.
What exactly, I want us to talk about, again, how design can either create a smooth flowing project or a project that can experience conflict, or how design can actually create conflict. And therefore why it's actually our first D. As I've mentioned earlier, design will be in this case by the architect. But design is a huger thing than just the architect's drawings. So I'll design, I'll understand what the client has said, I'll get that idea and that project, and I'll translate it into drawings that rhymes with the site and all the aspects around the site and the environment. And, think about the different issues we think about: sustainability, eco-friendly materials, etc., etc. But then I'll have to bring in other consultants who actually make the design final and complete. Yeah. We're talking about, and also that depends on the scope of the project. Remember when we talked about project delivery, we talked about that there's actually different consultants that come onto the project that help to execute it. So we are looking at engineers, we're looking at quantity surveyors, we're looking at the mechanical, what do you call them, MEP? We're looking at surveyors. So all these people will come on board to make that design complete before it actually gets into the construction stage. And the architect will come in to ensure that there is compliance and this building or this design meets code. Yes. And so I think these are things we need to understand slowly by slowly to create a foundation for how we get to where the podcast is meant to go, and that is how we end up having effective project delivery. Yes. So would you kindly talk about how it's possible that the designs that are created by the architects or this entire group of consultants under design can actually create, or is a possible creation of conflict or disputes?
Yes, like I said, the architects are the mothers of these projects. But there are times when a project goes to tender and you realize by just mere looking at the bills of quantities that there are a number of items that have provisional sums. Now, whenever you see provisional sums in bill of quantities, it is an indication that either the particular design for that component is incomplete or has not been done, or the particular specification. And I can give you a simple example. You look at the bills of quantities for a 10-story building, and there's a provisional sum for elevators. So either they have not determined who the supplier of the elevator is going to be, but now that would mean that the design of the concrete case where the elevators, the shaft, thank you for that word, the shaft is either incomplete or it's going to be inaccurate. But now this shaft, based on the design, starts right from the basements. So if you don't know the specifications and the details, the builder is going to issue a request for information and you may not have answers. So you realize that from day one, there's likely to be a dispute. Or even if there's no dispute, there's likely to be a delay.
Yeah.
Or if there's no delay, there's likely to be a variation. So right from the onset, it's very, very critical that all professionals come together at the onset and they complete the designs and the specifications before the employer goes out to tender.
Or actually have a design review.
Absolutely. Or have it at the commencement.
Yeah.
Maybe you can tell us about design review and why it's important.
And why it's important. Yes, because, what's happening a lot these days is that there is poor detailing. Yes. Yeah, that you can actually, and I don't know if this is architects doing this, but I would say that if you're an architect and you're professional, you've been trained, you know that you have to detail any project before it goes out. But we have this situation where buildings are being designed by non-architects, who I don't want to get into here. But the drawings then end up being not fully detailed like they should be, or they're incomplete. And then they're issued out, maybe because there's a timeline that needs to be met. And what comes out of that is that the contractor will then start issuing RFIs, requests for information, right, to the architect or to the engineer. And I think all these things are time-bound. Yeah, and once they're time-bound, there are also consequences to what happens to when you don't respond within that time frame.
Yeah.
Yeah, which I believe that is also, and then there are variations because the contractor is going to start assuming maybe this is what's supposed to be. Maybe they were talking about 50 millimeters. Maybe it should be what size of pipe is this supposed to be? Still, because there is that detail missing or that specification missing, and there are these other issues like late revisions, which are then going to get into the issue of time. Would you say? I personally would say it, but I want you to speak to it as well. The issue of effective project delivery is 100% tied to effective project management.
Well, I cannot say 100%, but to a great extent.
Okay.
And let me tell you why I would not say it's 100%. If you look at the 5 common causes of disputes, construction disputes, based on research by HKA. It's a global consulting firm. One of the top 5 common causes of disputes are lack of access to site. Many a time it may not be a project management issue.
Yeah.
But because a project is a government project and the government is supposed to compensate project affected persons. And this is an obligation that must happen even before the project manager comes on board. So the lack of access to site, you may not necessarily visit it to poor project management. Though it's something to do with a wider concept. First of all, even our laws.
Yeah.
How do our laws treat expropriation of property?
What is expropriation of property? You need to break that down for our viewers.
Our constitution provides that the government has a right to acquire property for public good. But that right can only be exercised if there has been prior adequate compensation.
Okay.
Now, the words prior adequate compensation speak volumes. It means before you even start the project or before you even have access to a project affected persons, they must have received compensation. Prior means before.
Before.
And that compensation must be adequate. Now
Who
the question is
adequate?
That is the question. Because ordinarily government relies on the chief government valuer. But the chief government valuer is an employee of government.
Yeah.
So the assumption is that the chief government valuer is a professional who would determine the values fairly. Now the question is, does he determine the values fairly? Now, right from the onset, there is going to be a dispute. And the dispute is arising out of policy issues, which have nothing to do with project management. That's just one of the examples. The other example, of course, is lack of proper interpretation of contracts.
Okay.
You may actually be a fantastic project manager. But at the time of tender, they set out a tender for design and build. Let me put it this way. They set out a tender which is employer design, whereby the entire design is going to be done by the employer. And then along the way, certain elements are left for the contractor to design without giving them a reward for that design. So however fantastic a project manager may be, there is bound to be a dispute arising out of that.
Right.
So it's important that we sort out policy aspirations of how projects should be dealt with. And we need to sort out procurement aspects. That when a project goes out to tender, there must be a meeting of minds amongst all the players so that the proper contract is chosen and the proper project fits a particular choice of contract.
Okay.
Yes.
Thank you for that, David. Now let's get into the decisions. We've talked about how what really entails in design generally, because we hope to unpack it as the podcast goes along. We've talked about how design can actually end up cultivating different disputes during construction. And then there will come a time when the disputes have come up and we have to make some decisions.
The decision making has various stages, and these stages are determined by the choice of contract that you make.
Okay.
The most standard contracts have tiered clauses. That is the PPDA contract, which is common for the government of Uganda projects, which are below $10 million. And for those government projects that are above $10 million, they usually use FIDIC. Now, both of these contracts, they have tiered dispute resolution mechanisms, One, that the first decision is with the project manager. That is the architect or the engineer or the QS. Whichever professional that the parties choose will manage them, will be in charge of contract administration. So that's where the first point of decision making takes place.
Right.
In FIDIC, they make determinations. However, a conflict or a discussion is always arise that this professional, the project manager, plays a dual role. On one hand, the contract says that that professional is an agent of the employer because the employer appoints them and pays them. But then the contracts state, particularly FIDIC, that while that professional, who is an agent of the employer,
Right.
when they're wearing the jacket of a decision maker, they are deemed not to be an agent of the employer, and that they are expected to make a fair determination,
Yeah.
and that they must act neutrally. So it takes a great deal of professionalism for you to be able to separate yourself from being an agent of the employer who pays you and being a neutral while making that decision. So that's the first point of call. But then FIDIC over the years had to separate certain decisions because previously there was never dispute boards. There used to be a dispute review board. So the engineer had a lot of power.
Right.
The engineer used to make decisions and they could only be reviewed at arbitration. That's how powerful the engineer or project manager was.
Yeah.
So there was innovation to put a stopgap to those powers. And they said, look, there must be another body that is neutral from day one, appointed by both parties.
Okay.
So hence comes the dispute adjudication boards or the dispute boards or the dispute avoidance and adjudication boards. They are appointed jointly by the parties. They are paid equally by the parties.
Yeah.
And they come in to review the decisions of the project manager. So they play a very good role in the sense that there is fairness at that level. And in fact, statistics show that almost 80% of all disputes determined by the dispute boards don't go further to arbitration or litigation.
Okay.
They're resolved at that level. And then, of course, arbitration takes the 20%, which is, of course, at a higher level that where there are disputes that either party is dissatisfied with, the arbitrators can review those decisions and make a final decision which is binding. So the critical distinction between this tiered clause is that the project manager makes a decision. It is subject to being reviewed by the dispute board, but the dispute board's decision is binding.
Right.
In essence, it must be respected and complied with, but it is not final until the arbitrator makes a decision. So the decision of the arbitrator is final and binding.
I just want to ask you one more thing.
Yes.
To complement that. Where does the architect really, generically speaking, where does the architect have a huge advantage when it comes to these kinds of decisions that you've talked about? Because I must point out that what you've just mentioned is not typical knowledge that comes from school.
Yeah.
From our side as architects. And therefore, that is why we identified the fact that partnering with CLI to get this kind of training, to get this kind of uplifting and empowerment, to understand what we already actually are and how we get to put it in practice as architects came in handy. Yeah. Yes. So now I want you to just help break it down for the architect listening. During this decision situation we've talked about, especially under FIDIC, the DAB, for example, what advantages or opportunities does the architect have out there in regard to that? Okay.
First of all, a dispute board is a panel of either 3 or 1 professional that is appointed by the parties to avoid disputes or to resolve them as and when they arise on site.
Right.
And their decision is binding for purposes of maintaining cash flow.
Okay.
Now, the most common dispute boards are established under FIDIC contracts. And the FIDIC contracts provides that the adjudicator or anybody who can be appointed to that dispute board must be a professional who is suitably qualified. So it does not restrict it to engineers or architects or quantity surveyors. It's simply a professional who is suitably qualified.
Okay.
So in essence, architects are suitably qualified to be dispute board members. They're also suitably qualified to be arbitrators. They're also suitably qualified to be project managers. The only distinction is that for you to effectively do that job, you must have the necessary skills and knowledge to do it. And that's exactly why we exist as Construction Law Institute. We conduct trainings in project management, in dispute boards, in delay analysis,
Right.
in how to do with price escalation. So we have an entire calendar of trainings that enable professionals to get empowered to be able to do this job.
Yes.
Yes.
Thank you. And now I just want to talk about those other decisions that you didn't talk about. So through the life cycle of a project, project initiation, then we have the planning, and then we have the execution, you'll find that those little disputes that come up from that have been a result of what happened on the architect's desk, for example. Yeah, I missed out a detail, I missed out a dimension, someone issued incomplete drawings, or one of my team, my team out to the other consultants missed out a detail. You realize that many of these little disputes will come up, and it's about how you actually respond as the architect or the project manager or the consultant team to that small dispute or that issue that has come up, that you actually have to make the decisions. Right from interacting with the client, the decisions that you make in design. No, let's put this here, let's orient it like that. Maybe the site is moving like this. So we have all these decisions that go through, and I think all those need to somehow be thought about when the contract is being put together. Earlier on, when we were discussing, we had a conversation about a real ad scene where architects, someone was saying that architects are actually leaving the trade because of things like the grind behind it, where the client is not interested in paying the fees that actually you talked about. If it's this kind of job, then it deserves that kind of. If it's premium, then it deserves this kind of budget. And you'll find that architects have a lot of work they put in, and you'll find clients that don't want to pay for that kind of work. And so, and I also mentioned where one mentioned that they were on a site and the contractor did not really interact with them professionally. And therefore, there were issues of mental health, physical health, and yet they are the architects on the job. Now, I don't know the story behind that, but is it possible that we need to think about these contracts a little deeper to even go as far as indicating a code of conduct between the professionals that are actually on the job that is away from our individual code of conduct, just to be that specific in a contract that is running a specific project?
Yes, first of all, you've talked about two major aspects. First of all, the first one is failure by employers to pay architects for their work. And secondly, a code of conduct for the various players. And the answer is yes. FIDI contracts have existed for over 100 years. These professionals have reviewed them over and over again to answer most of these questions that arise. We have set out as Construction Law Institute, together with the Uganda Society of Architects, to come up with a standard construction contract.
Yeah.
It will be able to address some of these things. And there are things which are already existing in FIDI contracts. For example, it is a contractual requirement that a contractor throughout the project cycle does not engage into any corruption or unprofessional practices.
What is unprofessional practices?
Now, unprofessional practices can mean there are specifications. You're supposed to bring a particular type of tile. They ask you to bring a sample. You bring a sample. It complies with the specifications. And then when you start laying, you lay something else.
Yes.
That's breach of contract. So We can put them in the contracts, but in order to ensure that there's a sustainable development of our projects, there needs to be a joint effort by all of us. Uganda Society of Architects, the engineers, the lawyers, the quantity surveyors, to lobby government to come up with a Construction Act. And with that Construction Act, it's important that then we establish a national construction authority, similar to the one in Kenya.
Okay.
That regulates contractors, that provides continuing professional education to these contractors. So once we have a professional pool of contractors,
Yes.
these are professionals are already regulated
True.
by their respective bodies.
Yes.
We shall have projects that are delivered ethically and within budget.
Okay.
Yes.
Okay, I agree. I want to just go back a little bit to the reason behind the podcast, the effective project delivery. And ideally, this is a knowledge platform to the different professionals and the public. What would you say are some of these major things that we're actually going to look at in the Consequential series that make up effective project delivery? What is even effective project delivery? I mean, from my side as an architect, I'll probably talk about, like I said, project management, managing the resources, managing, understanding the time, understanding the scope of the project, and executing what is actually in the plan, executing it into reality, but with a quality that has taken all that into consideration. What would you say to that? Effective project delivery.
Well, it's a general term, but it means that each of the contracting parties, all the contracting parties, must work in sync and not in silos. So it's very critical that all the contracting parties understand their respective obligations,
Right.
and they do it.
Right.
So if the contract has named President Jacqueline Namayanja as the project manager, I would expect the employer to respect that. And to respect that to the extent that they must leave Jacqueline to make her decision as a professional. But we have a challenge where the employer signs a contract with the project manager, to which the contractor is not aware of the terms. And therein, there is a clause that says that before the project manager makes a decision, they must first seek prior authorization from the employer. Now, you've taken away the decision-making aspects. You've taken away the independence of the project manager. There are going to be disputes.
Yes.
So employers, you need to, first of all, appoint qualified and competent project managers, but also you need to trust them, that they will make those
Yes.
decisions
Yes.
independently,
Yes.
within time, and that those decisions will be fair. So if that is done, that will be one aspect of delivery of projects successfully.
Right.
The next, of course, is the contractors. They need to build according to specifications. When they bring a sample, they should bring what they have brought as a sample.
You know, we have a lot of stories in that
Yes,
direction,
exactly.
where the man will tell you. I have an example where my project, the drawing had a full window, you know, from the floor to the ceiling.
Yes.
And I found the height of the window at 900.
Yes.
And the man told me, well, you see, we did the normal things. You know, these are things we're used to.
Yes.
And my question was, okay, so there's a drawing here and there's what you're used to.
Yes.
Well, what do you do what do you do in such instances anyway? Because I know that many contracts have the situation where, well, the ones that I've actually experienced, where a contractor is told that if you don't follow the drawings, then you're going to make good at your own cost.
Yes, of course. But a contractor who is not making a profit is not likely to finish that project. And also, what matters, because specifications and drawings are contractual documents.
Yeah.
So when a contractor says, I am used to doing this, That's not a contractual. There's no contractual basis for that.
That's a builder.
That's a builder. There's no contractual basis, but it's also because of the lack of professionalism, like I have told you. So basically, effective project delivery, like I've said, is when each of the players does their part.
Yes.
Even the bankers themselves, they issue guarantees to these contractors. But when a contractor has disappeared or they're in breach of contract, you go to a bank to have your performance guarantee encashed, and the bank starts playing games. They usually do it. They buy time to enable the contractors to go to court to get an interim order to stop the cashing of the guarantees. So you realize that an employer is frustrated.
Right.
Also, the various mechanisms.
Yes.
We have a very complicated process of procurement where when there is the best evaluated bidder, then people go to IGG. Then people go to PPD Appeals Tribunal. People go to High Court to get injunctions. So realize that a project that should have taken off in 2025 starts in 2030 because there have been wars over procurement. So we find that even the site has changed. The people who had been compensated have come back. So I think we need to work together, all of we, the players, the government, the employers, the bankers, the insurance companies that issue these guarantees, the professionals. Let us have a construction act that streamlines the entire construction period.
The Construction Act.
Yes, and we are happy that we can come together, all of us as professionals in the built environment, the USA, the engineers, the lawyers, the quantities. Let's come together and we lobby for the enactment of this Construction Act. It's the only way these projects can be finished on time and with sustainability.
Right.
Yes.
And going forward, these are things that we're going to be talking about in detail. For example, we will really double down on design, the stage of design. We'll get into, what the architect's role is, and we shall have detailed discussions, and we shall be engaging some seniors in these areas to just talk about the experiences and how the architect, for example, or any other role player on a construction project gets into ensuring that disputes are actually avoided. And before we even just conclude, there is an element that I find many of our Ugandan people, professionals included, have a weakness in, and that is the element of communication and keeping records. And I would think that I don't know. You'll give me you'll let me know if the arbitration cases that you've actually handled usually have that situation where they cannot produce a record to defend themselves, and yet it's very necessary. What do you have to say about that situation? When I was being trained, every little thing had to be recorded. Every communication to a client, communication to a consultant, whatever. And that's why we have record books on sites. That's why we have site instruction booklets. That's why we have all these things that are supposed to make sure there's a trail of communication as probably one of the aspects of good project management. But also in situations like this, where you need to defend yourself when a dispute arises, you have some proof.
Yes, at CLI, we emphasize records as critical for any claim or any response. And we have often emphasized the 3 R's, which are records, records, and records. But in my experience, we need to change the 3 R's to the 3 GR's. And these are good records, good records, and good records. Right. It doesn't matter if you keep records that are meaningless. And another thing that we emphasize during our construction claims training is an acronym that I would pronounce as CES, or CEES.
Okay.
For every claim to succeed, you must interconnect CEES. You must be able to interconnect the cause. There must be a cause of the claim. What caused it? Lack of access to site. The E is the effect. If you did not get access to site, so what? you must demonstrate that I had a work program. By December 2025, I was supposed to be constructing a bridge at Chainage 1400.
Right.
But because at Chainage 1400, you have not yet compensated project affected persons, my equipment is lying idle. My workers are lying idle. So you must connect the cause and the effect.
Right.
And then the next E is entitlement. It's a contractual clause. There must be a clause that entitles you to compensation.
True.
So what is the clause on delayed drawings or information? You go to, if it's FIDIC subclause 1.9, says that if there is a delay in responding to drawings or to requests for information, the contractor is entitled to extension of time and money. So E is a contractual entitlement.
Right.
And then S is substantiation. It means proof. What evidence do you have to prove everything else you've said? It goes back to your question. You must have good records, good records, good records. So for the example I gave, you must have an updated work program. You must have
signed off
approvals.
Yeah.
You must be able to demonstrate that you have this equipment which you hired, so you have contracts.
Yeah.
You must be able to show that every day you pay X amount of money for this equipment. And if you've been delayed for 14 days, you should be able to produce a spreadsheet that shows your exact loss.
All right, thank you very much for that, David. And I think going forward, we'll probably explore options where we can have our audience join in.
As we conclude this inaugural episode, I wish to thank President Jacqueline Namayanja for your leadership at the Uganda Society of Architects and for your vision that for us to achieve our respective visions, we need to come together. And this is just the first of many. So we shall be having periodic episodes about design decisions and disputes. So it's going to be a very engaging period of these stories, and we shall invite other guests to have this common discussion.
Yes.
And away from the discussion, we need to sit down and actually do the real work.
Right.
So we need to do the lobbying and advocacy for a good legal environment for us to operate and a framework.
Yes.
We need to make sure that the ADR policy that was approved by cabinet is put into effect. It has an aspect of training, so we need to see how both CLI and USA and other professionals go out to promote capacity building of our professionals.
Yes.
So I wish to thank you very much, our audience. We'll be back. Thank you.
We'll be back.